Welcome to the seventh lecture of this lecture series introducing the practice of international arbitration. The last five lectures of this lecture series in chapter 1 dealt with pathological arbitration clauses, and the last two of these lectures dealt with how to avoid those defective clauses. This lecture continues to deal with the topic. In addition, it also discusses the requirement of writing in arbitration agreements. Those following this lecture series would recollect that the last two lectures suggested three important measures to avoid defective arbitration clauses. These were the use of model clauses of arbitral institutions and arbitral truths, the use of translators with legal background for arbitration agreements involving more than one language, and three, the use of non-sentential arbitration clauses. Non-sentential arbitration clauses not only help in avoiding translation errors but also address other defects. For instance, parties sometimes use optional wordings in their clause, such as parties may refer disputes to arbitration. Note the word may, although they had intended that the dispute should be compulsorily or mandatorily referred to arbitration. Such defects can be avoided by the use of non-sentential arbitration clauses. In case you have not seen the previous lecture on the subject, please do have a look. The link is provided in the description to this video. Another problem while negotiating arbitration clauses is that parties at times do not appreciate the consequence of their choices. This makes them agree to something more than what they had bargained for. The case of Insigma Technology versus Alstom Technology, a 2009 Singapore Court of Appeal decision, is relevant on this point. We had also discussed this in one of the earliest lectures while dealing with pathological clauses. The arbitration clause in the dispute provided for Singapore International Arbitration Center's administered arbitration, but under the International Chamber of Commerce's arbitration rules. These were sophisticated parties, and it is difficult to understand how they could agree to this in the first place, because the ICC rules would provide for so many aspects relating to interference or, to put it precisely, administration by the International Chamber of Commerce. But how could the Singapore International Arbitration Center perform those activities which are under the ICC rules to be performed by the International Court of Arbitration of the ICC? The problem was, while negotiating the clause, the parties were perhaps not aware of the consequence of their choice, or they did not even think about it. In-house counsels and lawyers or law firms advising them should have been aware how arbitration rules would be implemented. So therefore, whenever in-house counsels or law firms are advising their clients as to arbitration rules and the choices that are to be made under the arbitration agreements, they should be properly aware of how those choices would be implemented or operated when a dispute arises. They should also be aware of the consequences of selecting a particular seat, the arbitral institution, and their rules. Failing this, they could end up in disputes like these. At the first instance, the parties disputed this particular clause in Insigma versus Alstom and went to the Singapore High Court, and then thereafter they went to the Singapore Court of Appeal through an appeal. So all the expenses and costs and time was wasted in questioning as to whether the arbitration agreement can be implemented or not. These could be avoided by parties properly drafting the arbitration clause. Failing this, they could end up in disputes. The next strategy is no strategy at all, but then you could call it the only strategy, that is due diligence. Look at every comma, full stop, and each letter or word in a dispute resolution clause. Fine comb it for mistakes. If this is done, then pathological clauses could be avoided. Another strategy, which is collaborative in nature, is that parties who are drafting or vetting these agreements can adopt the practice of exchanging their drafts or the marked up versions before they sit to negotiate, so that both parties are aware of what the other party wants to suggest. Now, this will give some time for party to review the other party's suggestions for defects and acceptability. There will be some time so that they can apply their mind and see how the suggestions, various suggestions in the arbitration clause or various components of the arbitration clauses could be made effective. To me, there are two extremely effective strategies while dealing with arbitration agreements. One of these is, of course, due diligence, no doubt. There can be no substitute for it. The other strategy is to have a checklist, that is, a list of contents or components of arbitration clauses. This would be useful, and whenever there is a draft that is received, say from the other side, the checklist can be used to draft or even vet the clauses. We will not discuss the checklist in this lecture, but we will do so in the next one while we are dealing with the actual drafting of arbitration clauses. The next topic that we will deal in this lecture is regarding the writing requirement in arbitration agreements. The baseline for arbitration clauses or arbitration agreements is an unequivocal intent to refer a dispute to arbitration. This is required by law in terms of Section 7, subsection 3 of the Arbitration and Conciliation Act 1996. And this writing requirement is also contained in the Unsettled Model Law. Section 7, subsection 3 states, an arbitration agreement shall be in writing. Although couched in mandatory language, the writing requirement is traditionally liberally construed, and this is the settled position. In fact, the statute itself provides for dilution of this writing requirement in terms of sections 7.4 and 7.5. Section 7.4 states an arbitration agreement is in writing if it is contained in a document signed by the parties. An exchange of letters, telex, telegrams, or other means of telecommunication, including communication through electronic means, which provide a record of the agreement, or an exchange of statements of claim and defense in which the existence of the agreement is alleged by one party and not denied by the other. So, a bare perusal of this provision would clearly suggest that an arbitration agreement need not only be incorporated in a document that is signed by all the relevant parties. Now, section 7.5 talks about another mode where this writing requirement is diluted. It says the reference in a contract to a document containing an arbitration clause constitutes an arbitration agreement if the contract is in writing and the reference is such as to make that arbitration clause part of the contract. So, section 7, subsection 5 specifically deals with a situation when a arbitration clause can be incorporated by reference to another document. Now, incorporation by reference was elaborately dealt with by the Supreme Court, which laid down certain important principles regarding this in MR Engineers and Contractors versus Somdat Builders Limited. It's a 2009 decision. The Supreme Court laid down 5 principles, which, if complied with, would constitute an incorporation under Section 7, subsection 5. The first principle said an arbitration clause in another document would get incorporated into a contract by reference if the following conditions are fulfilled. 1. The contract should contain a clear reference to the documents containing the arbitration clause. 2. The reference to the other document should clearly indicate an intention to incorporate the arbitration clause into the agreement. The arbitration clause should be appropriate, that is, capable of application in respect of disputes under the contract and should not be repugnant to any term of the contract. So what the Supreme Court says is mere reference in another document would not be sufficient to incorporate an arbitration clause contained in that agreement unless these essential conditions are fulfilled. The remaining four principles given by the MR engineer's decision also give clarity on this. The second principle is when the parties enter into a contract, making a general reference to another contract, such general reference would not have the effect of incorporating the arbitration clause from the referred document into the contract between the parties. The arbitration clause from another contract can be incorporated into the contract where such reference is made only by a specific reference to the arbitration clause. So the second principle makes it clear that mere general reference to another contract would not be sufficient to incorporate the arbitration clause contained in that other contract. The incorporation of the arbitration clause should be by specific reference. The third principle states where a contract between the parties provides that the execution or performance of that contract shall be in terms of another contract which contains the terms and conditions relating to performance and a provision for settlement of disputes by arbitration, then the terms of the referred contract in regard to execution or performance alone will apply and not the arbitration agreement in the referred contract unless there is special reference to the arbitration clause also. So sometimes what happens is parties say that this contract or the present contract will be executed or performed in line with another contract, another past contract. And that other contract may contain terms and conditions relating to performance as well as a provision for settlement of disputes by arbitration. In that case, mere reference to execution or performance of the other contract will only incorporate those terms relating to execution or performance and will not incorporate the dispute resolution clause. So in order to incorporate the dispute resolution clause in that situation, there should be a special reference to the arbitration clause or the dispute resolution clause. That is what the third principle says. Now the fourth principle says where the contract provides that the standard form of terms and conditions of an independent trade or professional institution, as for example the standard terms and conditions of a trade association or architects association, will bind them or apply to the contract. Such standard form of terms and conditions, including any provision for arbitration in such standard terms and conditions, shall be deemed to be incorporated by reference. Sometimes the contract may also say that the parties are familiar with those terms and conditions or that parties have read and understood the said terms and conditions. Now we will explain this fourth and the fifth principle together in a while after going through the fifth principle. Now, the fifth principle says where the contract between the parties stipulates that the conditions of contract of one of the parties to the contract shall form a part of their contract, as for example, the general conditions of contract of the government, where the government is a party. The arbitration clause forming part of the general conditions of contract will apply to the contract between the parties. So it is to be noted that the general rule of incorporation is that reference to another document should clearly indicate an intention to incorporate the arbitration clause contained in that other document into the present contract through a specific reference. So this is what the first few principles says. But there are two exceptions to this. The first exception is a standard form contract of an independent trade or professional institution. Like for example, FIDIC contract. Say if somebody incorporates FIDIC Red Book, that also incorporates the dispute resolution clause contained there. Now this is the fourth principle. And the fifth principle is also another exception. It says specific reference of a set of conditions of a party which contains the arbitration clause, then that specific reference of those set of conditions would also incorporate the arbitration clause contained in those specific conditions. Like for example, if say a government entity and another government entity enter into a contract, and one of the government entity has a standard terms and conditions or general conditions of contract available, and if the present agreement refers to those general conditions of contract and says those will be incorporated by reference, then such general conditions and conditions would apply to the present contract. And if those general conditions also contain a term regarding dispute resolution, that will also apply. So these are the two exceptions that have been provided in MR engineers against the general rule that incorporation by reference to another document would not incorporate the arbitration clause contained in that other document unless there is a specific reference. Now, another exception has been added to these two exceptions through the case of Inox Wind versus Thermocables. This was decided in January 2018. The exception that was added was a general reference to a consensual standard form of contract between the parties. Say, for example, parties had previously agreed to a particular agreement, then a general incorporation of that agreement would also incorporate the arbitration clause contained in that agreement. Now, all these five principles and the exception is built so that whenever there's an incorporation by reference, that incorporation by reference happens through actual consent between both parties. This is to protect the other party from any inadvertent arbitration clause. Now, another aspect regarding the writing requirement is that even though an arbitration agreement needs to be in writing, it need not be signed. We saw a few examples where there were exchange of pleadings and arbitration agreements through electronic communications, etc. In the recent case of Caravel Shipping versus Premier Seafoods, a case decided by the Supreme Court in October 2018, the Supreme Court held the fact that the arbitration agreement shall be in writing is contained in the 1996 Act in Section 7(3) thereof. Section 7(4) only further adds that an arbitration agreement would be found in the circumstances mentioned in the three subclauses that make up Section 7, Subsection 4. This does not mean that in all cases an arbitration agreement needs to be signed. The only prerequisite is that it be in writing, as has been pointed out in Section 7(3). That being the case, the present is a clear case where under Section 7(5) of the Act, read with MR engineers and contractors, the reference in the bill of lading is such as to make the arbitration clause part of the contract between the parties. So in this contract, there was a bill of lading. So therefore, that the reference in the contract was to a bill of lading, and the bill of lading contained an arbitration clause, so that was deemed to be incorporated by reference. So that's all in this lengthy lecture. In the next lecture, we will come to the core of the subject, that is drafting an actual arbitration agreement. Bye bye and stay safe.